So still across America, school children recite the Pledge of Allegiance every day. It may not be in the city of Philadelphia, it might be, but we know that this is happening in schools everywhere in the country. I think it's a little bit ironic that the Pledge of Allegiance was initially created for school children to recite. The population that is actually the least able to understand what it means. How many 5, 7, or 10-year-old kids do you know who understand concepts like justice, liberty, allegiance, republic? It occurred to me as I was thinking about our gathering today to think about and hear different voices and perspectives on those iconic last words of the Pledge of Allegiance and justice for all, that what I wanted to talk about was justice for children. Well, it turns out that justice for children is actually one of America's great unfulfilled promises. And it's not for lack of trying. We've had the best of intentions, and yet with more and more research and stronger and better insights, the fact of the matter is that we have continuously failed children in America. And we've been doing it for more than a century. This is a picture of the first juvenile court in the United States. This building is in Cook County, Chicago, Illinois. It was created in 1899, actually 7 years after the Pledge of Allegiance was initially introduced into our schools in America. The juvenile court was created by reform-minded citizens in Chicago who had this idea that we should treat kids like kids. It was a very simple idea, and not treat them like adults who committed crimes. So what did that mean? No prison, no criminal records, no punishment. We would emphasize rehabilitation and treatment over punishment. Within the next 25 years, by the 1920s, every state in the country had adopted a separate juvenile court for children. But because that court had no punishment in it, that also meant that the proceedings were pretty informal. This is what the inside of the juvenile court looked like in the 1920s in Denver, Colorado. This is actually a photo of a very prominent juvenile court judge in Denver. And what I want you to think about when you look at this picture is it looks pretty weird. That doesn't really look like a bench that we typically think about in courtrooms. He's kind of just having a casual conversation with kids. And think about what's missing from this picture. There's no other adult in that picture. That's because in the original juvenile court, there were no lawyers. There were no prosecutors. There really weren't any witnesses who testified, and there were no court reporters. So none of the trappings, none of the individuals that we today associate with a courtroom was present in that original juvenile court. And the other thing about the original court is that it was conducted behind closed doors, in secret. The public was kept out and in the dark. Those doors were swung wide open in the 1960s, when the case of Gerald Galt reached the United States Supreme Court, and it turned out that the juvenile justice system in the United States was a bit more Dickens than Disney. Gerald Galt was 15 years old. He was living in a small town outside of Arizona. He had been charged with making a prank phone call, a lewd phone call, to his elderly neighbor. For making this phone call, and I want you all to just sort of think for a minute, maybe you didn't quite do what he did, but I bet a lot of you have done similar kinds of phone calls or played tricks on people that you shouldn't have done. And again, 15 years old, right in the middle of his adolescence, he made this phone call. He was arrested. He was held overnight in a detention center without his parents even knowing about it. Within a week, he had been adjudicated delinquent, which means convicted of a crime, and he was sent away to an Arizona state training school for boys for 6 years for making that phone call. If he had been 3 years older, if he had been 18, his punishment would have been a $50 fine and maybe 30 to 60 days in the county jail. So much for treating kids better than adults. Well, Gerald's story reached the steps of the United States Supreme Court, as I said. And it turned out that when the case got there, it was becoming apparent that Gerald's wasn't the only situation of children in America, children going through the so-called juvenile justice system, experiencing something that looked very different than our notions of justice. When the case got to the Supreme Court, for the first time in 1967, the Supreme Court said, kids are people too under the Constitution. And the court famously observed in that decision that kids actually got the worst of two worlds. They got neither the rehabilitation and treatment and benevolence of our juvenile justice system, and they also got none of the process that we traditionally associate and have accorded for a couple of centuries to adult criminal defendants in this country. So the Supreme Court constitutionalized the juvenile court. After 1967, kids have had a right to court-appointed counsel. They've had a right to confront and cross-examine witnesses against them. They have the right to have the state, the prosecutor, prove the charges against them on proof beyond a reasonable doubt. And they have a right against double jeopardy. So it looked like we had finally put justice back into the juvenile justice system. But then crack cocaine and gun violence exploded across America. Between the 1980s, the late 1980s, and the early 1990s, violent crime soared in America. And it soared not just among adults, it soared among juveniles as well. That led to a very different kind of reform-minded policies for kids involved in the justice system. Adult time for adult crime became a mantra that drove state justice policy. States literally competed with themselves to see who could be the toughest on juveniles. And there was a rush to pass legislation that pushed as many children as possible into the adult criminal justice system. During these years, the 90s and the early 21st century, 200,000 children a year were being prosecuted as adults in this country. And that meant that they were exposed to the very same punishments that adults were exposed to: the death penalty, mandatory life without parole, all kinds of other mandatory extreme sentences. It meant that a 9, a 10, or an 11-year-old child could be prosecuted as an adult. That child could wake up in the morning in their bed, clutching a teddy bear under their arm, and go to sleep at night on a thin mattress on a slab in an adult county jail. And between 1995 and 2005, several young men in this country were executed, were put to death for crimes that they committed as children. And by the way, we sent thousands more of those children to jail to die. But the pendulum invariably swings. We know that. And so once again, the pendulum began to swing, and it took yet again the United States Supreme Court to intervene and try to right the path of our justice system in terms of how it dealt with kids. Between 2005 and 2012, the United States Supreme Court issued a series of 4 really groundbreaking decisions, really upending how we think about some of our most core constitutional provisions, in particular the Eighth Amendment, the clause banning cruel and unusual punishments, and how we apply those provisions to children. In those years, the Supreme Court banned the juvenile death penalty, banned life without parole for children who commit non-homicide crimes, and even for children who commit homicide crimes. The Supreme Court banned mandatory life without parole sentences and declared that children must have a right to have their individual characteristics of youth, those attributes of immaturity, of development, of educational and social and familial experiences, to be considered and factored into what type of sentence they would receive and whether or not they could in fact even receive a life without parole sentence. Finally, the last of those big decisions, the Supreme Court revisited Miranda. Everybody knows what Miranda is, and said, in the context of children being interrogated by the police in a custodial setting, youth matters. We shouldn't assume that kids will have the same perception of their ability to terminate that interrogation, of their ability to say, I think I want a lawyer, that they wouldn't understand that, and that law enforcement needed to take an extra step, needed to be particularly mindful of the age of the child before them, before they could proceed with that custodial interrogation. Okay, so again, sounds pretty good, right? We are making progress. Not so fast. In 2007, we received a phone call from a mother in Luzerne County, Pennsylvania. She was calling us about her 15-year-old daughter who had done something that sounded remarkably like the 21st century version of Gerald Galt's crime. She didn't make a snarky phone call, but she created a fake website and posted some snarky comments about her assistant vice principal. For that, she was charged with harassment. She was arrested. She had a 90-second hearing in front of the Luzerne County Juvenile Court judge. She was adjudicated delinquent for this crime. She was let out of the courtroom in handcuffs, and she was sent away to a juvenile correctional facility. 40 years after the United States Supreme Court said children had the right to counsel. Hillary Transu was that 15-year-old girl. And it turns out that Hillary was the proverbial canary in the coal mine. As we dug deeper into her story and stories of other kids in Luzerne County, we uncovered hundreds of stories of other broken lives, hundreds of stories of other kids who had experienced exactly what Hillary had experienced, sent away for very minor crimes with almost no process at all. In fact, between 2003 and 2008 in Luzerne County, 2,500 children passed before the juvenile court judge there. More than half of them had no lawyer. And of that number, 2/3 of those kids were sent away from their homes to juvenile facilities. That's not the only violation of due process that ultimately was uncovered in Luzerne County. It turns out that 2 of the judges in Luzerne County, including the juvenile court judge, were pocketing as much as $3 million in what the federal government termed a series of bribes and kickbacks from private individuals who had been involved in the building of a private for-profit detention center. And as the government described it, the scheme was about keeping those facilities filled with the children of Luzerne County. The Kids for Cash story, as it has become known, is now widely known across the country. Captured in the award-winning documentary film Kids for Cash, the film has also characterized this as probably the largest judicial corruption scandal in American legal history. Hillary's story is part of the Kids for Cash film. This is what Hillary had to say about her experience before Judge Chivarella.
I said to my friend, I said, man, did you have like a lawyer? And she was like, no, nobody has lawyers. And I was like, but haven't you seen Law and Order? Like, everybody has lawyers. Like, you're supposed to have a lawyer. Like, that's what, if you don't have a lawyer, you get one assigned to you. Like, isn't that the, and she was like, I guess it doesn't work that way for kids.
Everybody has seen Law and Order, except maybe the judges in Luzerne County. So wherever that wisdom comes from, sometimes it takes the wisdom of children to expose the follies and abuses of judges. Hillary's story turned out okay. Juvenile Law Center took on her case. We were able to get her home, back in her community, back into her school setting within a month, actually, of her first appearing in front of the juvenile court judge in Luzerne County. But as I said, there were lots of other stories of much less lucky kids in Luzerne County. Charlie Balasavage was one of those kids. Charlie was charged with receiving stolen property. Here's Charlie's story. Charlie's parents bought him a scooter from a neighbor kid in his neighborhood. It turned out that the scooter was stolen. Neither Charlie nor his parents knew that that scooter was stolen. Charlie was arrested and charged with receiving stolen property. Charlie's story is also in the Kids for Cash film. Listen to what Charlie and his mother say about Charlie's adolescence.
October, I came home for good. For all those years, I missed high school. I never went to a prom. All my birthdays, until my recent one, my 19th birthday, I was always in a placement somewhere.
I feel like it's my fault. Like it's my husband my fault that Charlie lost 5 years of his life. You know, they're supposed to be, you know, your good years, you know, your fun years, your teenage years. What does he have to talk about, you know, his lockups?
Charlie's story is a heart-wrenching story. Again, not different from the stories of many other kids in Luzerne County. But Luzerne County was yet another jolt, a wake-up call about how far we had strayed from the promise of the original juvenile justice system. But again, it wasn't an isolated story. At Juvenile Law Center, I and my colleagues asked kids that we work with who have been involved in the juvenile and criminal justice system, what did